Home Affairs Minister Dr. Aaron Motsoaledi has released the white paper on citizenship, immigration and refugee protection. This after a draft of the publication was approved by Cabinet earlier this month. It aims to provide a framework to guide the granting of residency and citizenship to foreign nationals. The minister is advocating for a review and temporary withdrawal from 2 international agreements on refugee protection. To unpack this further, I am joined by founder and director of Eisenberg and Associates Inc., Gary Eisenberg. Thank you so much, Gary, for your time here on eNCA. I find this topic quite interesting. Looking at those laws that we signed as South Africa back in 1996, 2 years into democracy, it seems we were too excited, and now we want to try and renegotiate. Because when I look at them, so many of the 147 member countries, even in Africa, were able to negotiate some clause.
Yes, that's true. But I think the bigger picture is also absolutely necessary for us to look at. The bigger picture is the executive authority, under the auspices of the government of the day, wants to make rights more restrictive for foreigners in general, not only refugees, not only asylum seekers, but for every foreigner, every person that's not a South African citizen. And it's in terms of that bigger picture that the white paper should be measured, not in terms of necessarily all of this detail. I mean, the white paper, if you look at it, is a lamentation, is a poem of regret on how the Department of Home Affairs has performed for the last 30 years. Some of the authors of the white paper have been at the Department of Home Affairs for many years, and it's actually an own goal. They've kind of admitted, as they did in the 2017 white paper on international migration, admitted that the way these immigration, citizenship and refugee laws have been implemented and administered practically by the department as part of its ordinary service provision has been abysmal. And as a consequence of that, both white papers, the 2017 white paper on international migration and this one, have lamented the way the department has come in to use the paper's word second best in a lot of these high court and constitutional court bouts of litigation. And that's because of the way the laws have been applied and implemented in terms of service provision. Yeah. So my take on this is that it really doesn't matter whether it renegotiates or resiles from the 1951 Convention on Refugees or any other international agreement. Whatever South Africa implements domestically as legislation, that legislation needs to be implemented and applied in compliance with the Constitution and efficiently. And those two elements have been missing. And this white paper showcases exactly that. And hopefully we're going to see an improvement.
If we do decide, if, for instance, after the public engagements and Parliament decides that, yes, we should withdraw from the 1951 Refugee Convention Act, what would it mean? What would it entail in terms of that? I want to ask you after this, what should they renegotiate if we do withdraw and go back? But to withdraw, what are the steps?
Well, the steps are, I think, as any international instrument with the United Nations, one has to, there's a withdrawal process, and that's pretty standardized. It needs to be passed by Parliament. It can't simply be resolved by the government of the day as an executive order. So there's a little bit of a process to go through. But then, if South Africa resigns from that convention, it's if South Africa is absolutely free to do whatever it likes, no longer bound by its international obligations. What South Africa should do, in my opinion, is let's look at this new bill, which combines refugee law, citizenship law, and immigration law into one statute. Let's see what public comments the minister receives by the 24th of January of 2024. Let's see a viable bill, and let's see what Parliament has to say about it. And I think that's the domestic process that needs to ensue to ensure that it's a democratically adopted change in legislation, whether and to what extent South Africa is going to curtail the rights of foreigners in general. I don't only want to speak about refugees, but foreigners in general is yet to be seen. Yeah.
And I think it's probably going to be difficult, isn't it, Gary? Because, I mean, if you look at it, for instance, maybe they didn't know in 1996, rather, that it would be this many people who flock into South Africa by now. And Motsoaledi admitting during his press briefing that we simply don't have enough in terms of public services for South Africans, let alone, the extra mouths that we have to feed. But, for instance, Botswana, Zimbabwe, Uganda, Angola, etc., they signed this 1951 convention, but they had clause. And one of the clause that I saw, for instance, with Botswana was Article 7, where it says that the exemption of respiraticity, to accept where the convention contains more favorable positions. For instance, in Botswana, they said that they would not be giving free public or government services to a foreign national, etc. So if we do decide, for instance, to negotiate on that in South Africa, what kind of debate is it going to open up?
It's going to open up a constitutional debate. Because remember, one of those reservations that is invoked by the White Paper is extending free education or education to refugees and asylum seekers.
Exactly.
And if South Africa is going to rework that and ask for a reservation in terms of a provision of the treaty or the protocol, or the convention of the protocol, then we are going to revisit some of these constitutional provisions in South Africa. And I see in the White Paper the ministers very sensitive about some of these new provisions in the Refugees Act being susceptible to constitutional scrutiny and perhaps striking down for invalidity and unconstitutionality. And we have to be very sensitive that our measure of what is correct in this country for everybody who lives within the sovereign borders of South Africa is our constitution, not what Botswana is doing or what Angola is doing. They all have different constitutional dispensations. We have to look at ours very carefully and be very sensitive what our constitutional court has said in interpreting and applying those provisions very liberally, especially with regard to human dignity and Ubuntu.
Yeah, and I mean, freedom of movement, for instance, self-employment. You can't be self-employed in Botswana and in some other parts of Africa, etc. There's also a rule, I think, I'll get to what I think you're saying, basically that the minister's white paper, what we agreed to in 1996 and wanting to, renege on that goes against our own constitution.
Yes, and I think the white paper doesn't do enough to criticize what the Department of Home Affairs has been doing since 1994 to curtail the rights of foreigners, very contrary to what our constitutional court has ruled. The extension, for example, rights of education, rights to dignity, rights to fair administrative justice enshrined in Section 33 of the Constitution. Remember, in the early days, Home Affairs wanted to deprive foreigners of these fundamental rights found in the Bill of Rights. And the Constitutional Court has ruled against the department, against the minister, against the Director General again and again and again, because constitutional compliance is what this game is all about, nothing more or less.
And I think I read in one of the clause of one of the UN, conventions that we signed in the 1951 or the 1967 one, it says that if you're an asylum seeker, you're obviously fleeing from a country where your life is no longer safe, right? So you go to another country and they're not supposed to send you away. But it also has a clause where it says that you go to the very first safe country that your country shares a border with. So, for instance, if you look at the map, the DRC, for instance, if you're fleeing from there, the first point would be a country like Kenya, a very good emerging market in the African continent. Rwanda would be another one, for instance, etc. But then, had South Africa probably, like you're saying, it's a bit of regret that is also, so palpable in the white paper, because had it signed something like that, we would have at least been able to share the responsibilities with the rest of the continent in terms of assisting people whose lives are in danger in their country of birth.
Yes, and I want to point out that, the 1951 convention was acceded to in 1995, and the protocol in 1996. And remember, the interim constitution was what we had in those days, and things evolved to our final constitution, 1996. And really, that is the measure. So if we have an individual from the DRC who's walked or bussed or been transported across a number of different states and then entered South Africa illegally without a passport, the government is suggesting in the white paper that that individual's rights to apply for asylum in South Africa should be curtailed. He should be deprived of that benefit. And only if South Africa had made that specific reservation, we wouldn't be landed with that problem. Exactly. Well, what is wrong with a person like that applying for asylum over here in terms of our constitution? Is it we don't like foreigners doing that? We want foreigners to have fewer rights in South Africa. I think the bigger picture also needs to be very transparently set out. What is the ANC's policy on foreigners in general? And that's why I've reiterated that again and again throughout this discussion.
All right. Well, thank you so much for explaining all of this to us, because some people, and I wonder if you can probably clarify the debate, some people would say it's so unfair that every time our ministers say that there should be laws around the services that are shared with those who are not from this country, we are labeled xenophobic, whereas the countries they are from have clause from these conventions where they say the exact same thing that our government is trying to achieve. So what you're saying is that it's too late for that.
What I'm saying is that the concentration should be on our constitutional Bill of Rights. Yeah. That's our measure of what is correct in South Africa, notwithstanding what they're doing in other countries. And I mean, the white paper does a fine job in painstakingly taking examples from other African states and other foreign countries. None of those other countries, none of those other African states have our constitutional dispensation that so many people fought so bitterly to have in the first place. We have it now, and whatever our president and whatever the executive authority of this country may say, they need to play the game within the parameters of our constitution, one of the greatest constitutions on the planet. And we have to be true and we have to be correct to comply with it.
Yeah, and I guess it's all about actually making sure that the laws that we already have in South Africa actually work and are implemented. Gary, thank you so much for your time and for speaking to me. I find this topic really interesting. Founder and director of Eisenberg and Associations, Inc., Gary Eisenberg.